In this video, I'm going to talk to you about what to expect after your lawsuit has been filed. Leading up to filing a lawsuit, you'll first have an interview with your attorney. These are often conducted in the attorney's office or sometimes over the telephone even. In that interview, you will discuss the facts of your claim, the strengths, the weaknesses of your claim. You will disclose any witnesses who may have seen or witnessed the incident in and of itself. After that, your attorney will typically send a letter of representation to your insurance adjuster. In that letter, your lawyer will ask the adjuster to limit his or her contact with you and conduct all correspondences through your attorney. Often, any initial issues with your claim are addressed in that letter to the adjuster. After that, your law firm or your attorney will order your medical records and begin conducting his investigation. Once the lawsuit is filed, you are now on the court's time schedule. Some jurisdictions are quick, with the date between your injury and filing suit and then the end date of your trial being scheduled relatively quickly. Other jurisdictions are not so fast, and it can take months and sometimes even years to get your lawsuit worked up and on a trial schedule where you can have your trial. The beginning phase of a lawsuit, and by far the longest phase, is called the discovery phase. This is the phase of a lawsuit where both parties exchange written discovery questions to each other and depositions are conducted. During this phase, expect a call from a paralegal at your attorney's office who will go over interrogatories and requests for production with you. What these are written questions that you have to answer and sign to the best of your knowledge, truthfully and under oath. Also, request for production is where you are being asked to produce any documentation that relates to your claim. A lot of times these are wage records, accident reports, and medical records. The next thing that will happen in the discovery phase is that the defendant's attorney will notice your deposition. And a deposition is a time where the law firm for the defendant gets to take your testimony under oath in an attorney's office, and there's typically a court reporter present to make a record. Your attorney will meet with you prior to your deposition to help you prepare. They are very straightforward, and they're very common, and they happen in almost every personal injury case. In that meeting, the lawyer will help you know what to expect. Also, your lawyer may take the deposition of any witness or any other parties that are a party to this lawsuit. At the conclusion of the discovery process, a mediation will typically be scheduled. A mediation is a meeting between the parties, and typically there's a mediator. Over 90% of personal injury cases settle, meaning an agreement is reached and a check is forwarded to you as the injured party prior to a trial. Mediations typically last up to a full day, but usually half a day, a couple of hours. And in a mediation, you will be in a room with your attorney. The defendant or your employer, if it's a workers' comp claim, or a representative of them will be in another room. And there will be an impartial mediator who takes offers and demands back and forth between the parties. This is often your best chance to reach an agreement and a settlement of your claim prior to going to court. Once you settle, if it is a personal injury claim, it takes a couple of weeks usually for your check to arrive, and you'll have to sign some settlement documentation. If it's a workers' compensation claim, workers' compensation settlements have to be approved either by the judge if the claim is in a lawsuit, or it can be approved by a state ombudsman with the Department of Labor. If the mediation process fails, the next step is to go to trial. And like I said at the beginning, that can be months from when your lawsuit was filed or even up to a year.